Good morning. Happy Friday. It seems that my viewership is very concerned about when the court is going to find that Chille is a vexatious litigant, that the court is going to put a stop to all these frivolous lawsuits that Chille's filing. And my answer to that is probably never. I'm not saying that Chille files great lawsuits. Obviously, I don't think that the current lawsuit filed in Nevada District Court, Nevada Federal District Court, the Federal District Court for Nevada, I don't think it has merit. I think that it is vexatious. Despite that, there are a lot of hurdles that are going to come into play before the Nevada Federal District Court is going to find Chille vexatious. The first thing that's going to have to happen is that the Ironton defendants are going to have to prevail. Now, they most likely will prevail. But the next thing that has to happen, which is highly unlikely to happen, is that either the court on its own motion or the Ironton defendants have to file a motion to have Chille declared a vexatious litigant. That is highly improbable to happen. There's very little reason why Ironton would do that. So that's the second thing that has to happen, and it's highly improbable that second thing will happen. Now, in order to prevail on that, they're going to have to show that, number one, the lawsuit lacked any legal merit, and while it's very dubious that there is any legal merit to it, the court may give Chille the benefit of the doubt with the defamation claims. So a part of it may have some legal merit, some fraction of a bit of legal merit. And based on that, the court might say, you know what? There was at least some merit here. May happen. But the second thing that has to happen is the court has to find that there is some sort of a history of this. And the court isn't going to look at the Massachusetts District Court. That's a different circuit, number one. And number two, there was no finding by that court that the case that Chille had against Peter and Abrams was frivolous. There was no finding there. So despite what you may think and what I may think about how frivolous that last case was, there's no finding by a court that it was frivolous. And those facts and that evidence and those defendants aren't in front of Nevada District Court. So ignore that. So the only frivolous lawsuit that has been declared to be frivolous would be the one in Nevada. The Ohio one, the one in the District of Ohio, hasn't been declared to be frivolous. There was no... Chille could not succeed on the merits, 12b-6. There was a motion to dismiss and a motion for summary adjudication. The defendants prevailed on both. But there was no finding that it was frivolous. So there's been no findings in any court that I'm aware of that any of Chille's filings have been frivolous. So if the Ironton defendants move in the District of Nevada to have that case found to be frivolous, that would be the first one. And the court is very unlikely on the first one to be like, well, bro, you can no longer file a lawsuit again without judicial review. Because Chille, no matter what you think of him, has a First Amendment right to petition his government for redress of grievances. And there has to be some significant showing in order for the court to strip him of the bulk of that right. So that's big step number one. Step number two, even if he is found to be a vexatious litigant, which is absurdly unlikely. It's about as likely as me being the next person to marry J-Lo. I'm already married. I think she's already married. I've never met the woman. She would never have any interest in me. So it's about that level of likelihood. The 1 in a billion chance. So even if that happens, Chille would still be able to file lawsuits. The only change would be he would have to submit the lawsuit to the federal district court before he could file it. He'd have to submit it to him and get the court's approval before they will issue the summons, before they'll allow a summons to issue. So he gets to prepare his complaint, he gets to file it, and the court is going to review it. Normally the court doesn't review it, but the court will review it and make sure that on its face there is some plausible merit to it before the court will issue the summons. That's the only difference. And on its face, a lot of these have merit on its face. Like the LVMPD one. Did they hit him in the balls? You don't know based on the pleading. You don't know. He pleads they hit him in the balls. That would be enough to get that lawsuit filed. You get punched in the balls by a cop, that's a 1983. I mean, that's excessive force. Cops aren't allowed just to punch you in the nuts for no reason. And that's what he alleged. So I get that people are frustrated with Chille, but it's not happening. I just want to be clear. It's not happening. There's a certain class of prisoner in the federal courts and maybe in the federal penitentiaries and maybe also in state penitentiaries who get their jollies, who have nothing to do all day long but to file lawsuits against their jailers, against the guards. That's all they do. And they file them in forma pauperis. They file them like basically on the taxpayer dime, and those get reviewed by the courts before they get filed. And a lot of those go through. So the court has to look at those automatically because these prisoners are filing in forma pauperis. I have no money. The court gets to look at it before the court will issue the summons and be like, yes, this has merit, enough merit that we can proceed, or no, it doesn't. And many of them go through because it just takes you pleading the right things to get it through. And they do, and it's not like they win these things. I mean, most of them that do get through, they still lose, but they get through. And Chille will file enough that he'll probably still get through. So your hopes that Big Daddy government coming down and putting a stop to Chille's shenanigans, probably not going to change anything. Anyway, that's all I got for you today. Thanks for watching. Have a great day.